Research Institute. I'm extremely happy to welcome all the staffs and students of various departments to a webinar on encouraging creativity and development through intellectual property rights and innovation, organized by a faculty of ENT first year BTech. To present on the topic, I'm glad to welcome our chief guest, Dr. J.ARUN sir, Dean Innovation and Entrepreneurship.
Is my screen visible? Is my screen visible to you all?
Yes, sir. Visible, sir.
Yeah, thank you. Thank you. Okay. So it's my pleasure to address the audience regarding the creativity and the development and what is the contribution of intellectual property rights towards the innovation. So all these terms, creativity and innovation, intellectual property rights, we will just go to the topic. First of all, I thank Subhashri ma'am for giving me this opportunity, and I thank the management to give us a liberty to work on, 24 into 7 about innovation and entrepreneurship related activities within the campus and across the campus. So let us go to the topic. What are the objectives that we are going to go through in this session? Or one is we are going to go through about IP index. Like, you have to know the fact sheet, what is happening across the globe first, and then think local. You have to know what is the global scenario in patents, and then IP, and then you have to focus on the local needs to be addressed. What is the problem statement and which one to work with, and what is my contribution to the IP to the country, so that later automatically the IP index of the country will go up. So then objective 2 is about IPR basics. I'm going to just rush up about what is this IPR is all about, what is a governing organization, patenting process, forms and forms of patent. Now, what is a term, like, you might be confused with what is forms and forms. Forms in some types, what are the types of patents? At the same time, what are the kind of forms are available for patent filing? And NPI of patents, that is non-patentable inventions of patents, like it has an section 3 and section 8, section 3 and section 4 of clause in the Indian Patent Act, where we have something to list out where it comes under non-patentable innovations. Like will just find it out there. Now, the objective 1 is like, the IP index and the innovation index. Like, what is the index is all about? Like, we have a lot of indexes. Well, pollution indexes, water pollution index, global innovation index, IP index, happiness index is there. Lot of indexes are there. What this index states as? This is an important thing. Like, this is a fact sheet. Sometimes it will be hard to know that all the metro cities, okay, groundwater is unfit to drink. It is not potable because water quality standards index says this. Air quality index says that the air that we breathe is unfit. Lot of standards are there. There are alarming standards situations we need to aware of. These kind of index have a set of parameters. When it comes to index, we know the fact sheet what is happening. Now, about and what is the properties that they have made. So the number one country, in the world is United States. Total overall score for the IP index is about 95.48 points first. Now this is an IP index of 2023, and it's already happening now. The latest updates, okay, and still US is leading, UK is second, France, Germany, followed by France, Germany, Sweden, Japan, Netherlands, and Ireland, Spain, Switzerland, Singapore, South Korea. All this list is going on. I'm going to the second slide. And Taiwan, Morocco, Mexico, China, Costa Rica, Malaysia, Turkey, all these countries are listed out. And then India is in 42nd rank out of the IP index. And I'm not telling that India is far behind or something like that, but still we are doing our greatest efforts in filing the patents and then commercialization of IP. All these things, every country is putting in hard work nowadays. Like almost all forms of patent we are doing great, but still it's not sufficient, and we should not blame the country for the ranking process. It is an individual collective responsibility. Each and every one of us is responsible for this ranking. So we have to make sure that we choose the particular problem statement, we work on, we do research, we do the innovation, we identified a feasible solution for the problem statement, prototype it, okay, and then patent it, go for design patent, file the copyrights. If you are a company, if you're a startup, register your trademark. All these things you need to, collectively we have to work on. We need to do more technology transfer. We need to do more focus on commercialization. If you do that, automatically this index will keep on increasing. And our overall ranking is 42, and then total overall score is around 38.4. But China's overall ranking in the same IP is in 24th rank, the score of 57.86, and then this is the patent score. See, this score for this is previously I've listed out the overall ranking, right? So what is the kind of patent score is there? Now, China is doing great in that. Okay, patent score is about 80.83%, and we are in 33.70. And still government is creating a lot of awareness programs, like Kapila initiative is one among it, where government is spending all these efforts on financial grounds. They are doing a lot of subsidies are there. Once you file a patent, government is taking all the responsibilities. For filing cost will be reimbursed to you, and all these things are happening right away to encourage the participation, not mere participation. This is not a program kind of thing, but still motivates all the stakeholders to file patents. And so now it is our responsibility to increase the score right away. And if you're not interested in this ranking number game, right? Nobody the first rank or something like that. At the end of the day, the ranking and achievement is totally different. Sometimes all about then some of the factors like commercialization of IP. How many ideas are commercialized? What is the score in it? So commercialization of IP, we are in a good state, some not good state. We are better than many countries. 41.67% is there, but it is not sufficient. And we need to increase the score rating, and we have to ensure that each and every patent that we file have some commercial importance. At least either we have to go for a technology transfer, or otherwise we have to go for the commercialization. So China's commercialization IP asset score is less than us, 38.83, but still just look at this. Canada and Australia, Germany, Switzerland, and France, they were 85 and above. So to the top score of Australia is about 95.83, and Switzerland is also doing great, 91.67. The commercialization of IP, that much, like this is a great score where almost all the patents those they file make sure that they have a industry collaboration, and it's interdepartmental, multidisciplinary, so that all the gaps has been filled, and there is always a need in the commercial space to such pattern. When you think of in the TRL1, technology readiness level 1, that time itself collaboration will start in those countries. So we also need to act in such a way that we need to improve our commercialization of IP asset, in a better manner. Now, so what is Global Innovation Index? We saw about the IP index. Global Innovation Index is also having some inputs and outputs. And you know what? The first country who is the global leader in innovation and how they are doing it, a lot of research is going on, because Switzerland is the #1 country leader of Global Innovation Index. And if you look at the left side, just think it of from for the last 5 years, it is like the country states as such in the first rank. And there is always a debate is going on, why the country is unbeatable. Because second, and from second rank to 10th rank, all the shuffling is happening over there. And we got when you deep dive into it and then analyze it, some of the points are very nice to learn. High quality universities focusing on interdisciplinary research and innovations. And almost the quality of the university, our education system always starts with us. If you are good at something, and if you're good at collaboration, if you're good at passionate about research and innovation, and then automatically the ecosystem changes. And almost every universities, we have a lot of good and kind of equipments, equipped with good infrastructure. All these things are, we have an incubator supporting your innovation. So we have to participate in everything. And then we have a good they have a good regulatory environment. They have a good infrastructure and industry connect. And then they have joint patents. Why Switzerland is unbeatable, I'm talking about. They have a joint patents between industry and academia, and they have a joint patent between the faculty and students. Okay, and interdisciplinary joint patents are there. And then innovation investments into results, output is great over there. That means whatever they patented, they made into they materialized everything. They made it as a proof of concept, minimal viable product, and so on, prototypes and so on. So a high number of scientific publication with good H index is also happening over there. That's also contributing to one of the factors. So if you check it out here, this is the QS universities, and then patents filed, and then citable H index. This is China, and the second next one is India's. In almost we have QS universities, we have a best universities, and we have a good citable H index, which is also a lot of awareness has been created in scientific publication. India is doing great, but patent we are almost nil. Okay, when compared to other countries, so we have to create more and more awareness, and government is doing that. As an individual, you have to do it. That's the thing that we need to work on. So design patents, copyrights, international patents, trade secrets, trademarks, and mostly commercialization of all these, we need to focus on. Now, this slide, I'll just presenting this. See Switzerland, how good they are in the rating when compared to all the other countries. Now, objective 2 is we have to know about IPR first, what is intellectual property rights is all about, what is a governing agency or something like that. So what is patentable subject matter? When we can say this is patentable and this is not patentable, in the sense, innovation must have both the product and process, either product or process, or both it can be. And there are 3 criteria which is subjected to patentability. Is one, it should be new or novel. And The second one is it involves an inventive step, and the third one is it should be capable of having an industrial application. And most of all, like you have to consider, as an innovator, you have to consider that your innovation should not fall in section 3 and section 4 of IPR law of India, that I'll list out in the last slide, what is subjected to non-patentable innovations. And then we have some global leaders who taking care of innovation. The organization name is World Intellectual Property Organization, which has been specialized an organization of United Nations, where they have this balanced and then accessible international intellectual property system. Because WIPO, there are about 190 plus member states who have signed in the agreement. Once you file an international patent, all the 190 plus countries, your patent will be protected. Okay, once you file a national patent, your patent will be protected within India, within our country. So WIPO is established in WIPO convention in the sense gathering, and then where in 1967, and it has a member states to promote the protection of IP, and its headquarters located in Geneva in Switzerland. So what is a brief history about WIPO? Basically, it is like, I've listed out in the first slide about 1967. This organization has been formed, and this organization was started in a failure mode. Like, in 1883, there is something called Paris Union for the protection of industrial designs were formed, and in Bern Union is formed in 1886. And they formed an international bureau, combined both the law together in 1893, where the treaty is most successful actually. The Paris Union and the Bern Union were successful, but the international bureau collapsed. The operation is success and patient died. So similarly, what happens later is they identified the treaties were very successful, but the organization was the huge setback. Then they formed an organization called World Intellectual Property Organization in 1967, which came under the hood of UN as a specialized agency, and a lot of member states were there. And the income, most look at it here, like 100% major income comes from the PCT, Patent Cooperative System, and the rest of all through the other agreements. So 71% of the income falls through the Patent Cooperative Treaty. Then these are the treaties that everything is open source. You can surf in net about WIPO, World Intellectual Property Organization. Read all the beautiful, case studies of what is happening, because every companies are suing each other because of patent infringement. You have taken my design, you have taken my technology, and so on. All the case studies has been open source over there. You can read X, Y, Z companies. What is the struggle that they are making up? What is the what is the case thread? What is the decision of patent examiners, patent general? Everything we can able to look through in the website. So Paris Convention is which protects the industrial designs basically. Bern Convention protects the literary and artistic works. Madrid Agreement protects the trademarks, registration of trademarks. Hague Agreement is the agreement which protects the international registration of industrial designs. Patent Cooperative Treaty is what PCT. I said on the previous slide that WIPO protects the international agreement, international patents also. So it comes under PCT. So the two things that mainly when you file a patent, whether it is a national or a PCT application. Okay, so if you go for a PCT application, the protection is international. Budapest Treaty, which preliminary focus on deposit of microorganisms. Now, what is patenting process? Objective 3. So, patenting process starts with filing of a patent, both the provisional and complete specification. If you file a provisional specification, complete specification you can file within 12 months. Like for example, I'm a researcher or innovator working on a concept. Right now, abstract is ready, and I don't have complete findings. Now, then you can file a provisional patent Within 12 months of time, you can file up in this complete specification in a detailed application I'm talking about. And publication of the application is what will happen, promptly after 18 months of preliminary, filing. Or you can go in a fast track mode is also there. If you want to push it in, earlier, like you want early publication, that you can do it. This is the first step for a patent application is accepted. Look, once you file a patent, a receipt will be given to you, and follow-up numbers will be given to you. Then patent will be published in the journals, and request for examination, you have to give a form, and within 48 months from the first date of filing, this process will be done. And then examination issue of FAIR, like FAIR is first examination report. Examiner will examine your patent novelty, as I told earlier, novelty, utility, and inventive step. They will just read the data, and wherever they find the queries, they will raise, and you have to reply for the FAIR. And then it's absolutely the decision of examiner to give the patent, grant or reject your patent. And then again it will be published within 12 months. If anybody want to oppose that particular patent, they can do it to they can write it to controller. So the controller decision is final. So this is a kind of patent process from the filing to grant. Okay, and it varies from each and every patent. The timeline varies because how fast you are responding, and what is the core competence is all about. What is the streamline that you are working on? Based on that, it will be. Now this process has been speed up by the government, so that more patents will be filed on, and a lot of things are going on in it. Like, so you have different patents also. There's a complete patent, and there is something called design patent is there. Okay, within 6 months you will get a response, and then within a year you will get a grant of a patent also. In design patent I'm talking about. So what is the forms of IPR? Like, what are the different forms of IPR? One is copyright. Everybody knows about it, right? Like basic, it's a compulsory license. Once you released into the book is released into market, copyright will be there. And once you sing something, some of the new lyrics or something like that, everything, it's a kind of compulsory license. You want to license it, you can do it, and it's an exclusive right, for you to protect your particular kind of music or literary or artistic works. Everything can be patented through copyrights. And there is a lot of issues with the copyrights. I'll tell you that in the forthcoming slides. After looking this particular picture, what comes in your mind is, this is a kind of thing, like many innovators hire independent consultants, and then they develop the websites. Once the website is very famous, like like reach out it reached into market, the copyrights goes to the consultant who created the websites. So you have to make an agreement for work made for hire, so that this is my concept and you are working for me, and you are doing for the website development. If you're not making this work made for hire agreement, then the copyright goes to them actually. So because this is a selfie which is taken by the monkey, where the camera is from David Slater. There is still a debate is going on whether this picture copyright belongs to the monkey or the David Slater. So that is a kind of situation which is happening over there. So you need to understand, who is the owner, ultimate owner for this picture is the monkey, and David Slater does not have any kind of ownership claim to this picture, because he is awarded a best picture in one of the wildlife photography, but the owner is the monkey. So this way it works. So you need to understand how it works. So this is all about trademarks, different forms of patent I'm talking about. Different, in at the end of the corner, like it will be written as TM. or registered or service marks. So trademark usually, what is a word that you're using and what is the font, what is the word, what is the color, everything matters. So it should be, and it is protected, like I said, no, international protection of trademarks, it comes under the treaty, where you can protect your particular logo or the word, the color, the font for the particular you know name of the company or a product of products. So all these things can be protected through trademarks. Trade secrets. So we everybody when it comes to trade secret, everybody will think of Coca-Cola is a trade secret and KFC's ingredients is a trade secret, but that is not true. Like only these companies' trade secret is not a trade secret. Even your research logbook, okay, you are entering your research findings every day. You are putting your date. You are entering your research findings. Your laboratory books, no, that notebook also comes under trade secret. Now tell me, whose responsibility that to protect your trade secret? So if you're just keeping that all your findings just like that in the laboratory desk where everybody can able to access it, then that is not a trade secret at all. So you have to, when it comes to trade secret, it is our individual responsibility for the innovator and researcher to protect your trade secret, your findings I'm talking about. That is how Coca-Cola is maintaining world's best locker facility for maintaining their trade secret. Now, next one is a different form of patent is geographical indication, where 61 different types of spices, species of mango is being patented, and Alfonso, Monsoon, Malabar coffee, Nilgiris, Assam teas, Basmati rice, all these things comes under geographic indication in a particular place, traditional way of method of preparing, and then there is a lot of inputs for that particular people. GI has influenced a lot, and GI protection is mandate for the things which whatever they prepare in the particular place, which is famous. I'm talking about Darjeeling tea, shrimp paste from Vietnam, and then Varanasi silks here in Kanjipuram silk, and then Arni silk. All these silks varieties from a particular place comes under GI tag protection, and Tanjavur Veena is also comes under GI tag. So what is in GI tag? You can ask, that's the practice of tradition from the technology of making it and everything it belong to a particular community or a particular place, so that nobody can able to use and say, for example, I am in Chennai, I'm going to manufacture this, say similar like Tanjavur Veena, and then say this is Tanjavur Veena. I can't able to claim it because GI tag, the particular local people of Tanjavur who knows about it, the manufacturing practices and the tradition, only they can able to sell it. That's the power of GI tag. And now, what is prior art? We are innovator, we are researcher. I'm going to file a patent. You have to do this. One is you have to search and find out in Google patents and patent scope and country-wise search. We have something called IP India Services gov.in, where you can search. The keyword search is important. For example, and claims. You can in Google patents you can type about, for example, automatic rain sensing wipers for the automobile or cars. You can type it in the Google patent, and just you can, after this talk, you can just check out your research idea or innovative idea in the Google patents. You just search it so that you will get around, mostly in whatever the keyword that you type, a minimum 10,000 to more than 2 lakhs results will be there for your innovative idea. So you can ask me one question, when it is novel, how come this many people file this many applications and this many grants are there? So everyone will be having different claims and different topics they will be working on, and different angle of research will be there, different application will be there for the same kind of thing. So drafting the claim is also such an important thing. Okay, claim in the sense you can for example, this is a water bottle, and if I say this is water bottle, this is a bottle designed to fill water. That is claim number one. Claim number two is like I can fill milk in it. Claim number three is I can even fill oil in it. So why can't you write a claim where it covers in a broad spectrum, like write a claim stating that you can fill liquid substance in here, so that everything will be fit in. So broader way you can write a claim. You have to write a claim, and then there is something called dependent and independent claims. Okay, supporting to the first claim or something like that. And it's like an exam sheet where you have given a patent office will give additional sheets also. It is again every additional claims you have patent office will charge you. So sometime to some extent your claim limited claim is good in a broader perspective, or if you are stating the individual claims, then make sure that you fit in everything. So kind of like you go for the virtual to, like once this thing is completed, the session is completed, you can check it out, the claims how they have drafted for each and every patent in the Google patent. And the patent scope is all about the like for example, I'll just go so that you will know like how it is. So this is a Google patent where I've typed rain sensing wipers for the cars. I'm just going for the back, like 34,180 results are listed out. Okay, and the same kind of thing I have just gone for the patent scope. I'm just copying this, rain sensing wipers for cars. So I'm accessing the patent scope of World Intellectual Property Organization, and I'm just pasting up. See, when you enter, sometimes it shows like no results are found in the match. So the keywords are very important. So just make it as rain sensing wipers, not for cars or something like that. And then just give an enter, where you get around 66 results: vehicle monitor, method of controlling a motor vehicle wiper. See, this is an international patent I'm talking about. So World Intellectual Property Organization take care of international PCT application related to rain sensing wipers. So each and every when they applied, what is a university? Who is the applicant? Okay, is an individual or a university? Who are the innovator? If you click down the patent, the complete specification will be listed out. Everything is open source. Everybody can able to access these sources. And here also in the Google patents also they have listed around 34,000 results are there. And if you just click one, vehicle environment monitoring devices, and here it will be listed out, everything will be there: innovator, and what is the company that he is assigned to, when it is applied, whether the application is granted, and whether it is an active or it is going to expire, what is the 18 claims that they have listed for, everything is here. All these things you came to know, like you will know like what is happening over there. So that is really important. And one sec, I'll just start presenting. Yeah. So without proper claims, and your protection will be like this, like this is a kind of this is up to this only, this particular bar is there, so the cycle is can be easily stolen up. So uh, drafting a claim is such an important thing, so that you know what are the things to be needed. Okay, and then in objective 5, non-patentable inventions. What are non-patentable inventions? We need to know, because at the end, if you're inventing something and which is comes under non-patentable invention, no use. So from section 3 to 4, like mere discovery is not patentable. You walking somewhere and you find a new metal and a new microorganism, new plant varieties, nothing is patentable. Mere discovery from this planet is not patentable. And mere admixture is not patentable. Eraser is there as an innovation, pencil is there. You combine both and create an eraser and pencil. That is not patentable. And that is mere admixture is not patentable. And innovation related to surgical, curative, prophylactic, and treatment purpose is not patentable. any curative device that you find for COVID related issues like deadly diseases, which is not patentable. And inventions related to agri practices, you followed a peculiar pattern to harvest or plant this rice varieties or something. You get a good yield, and you want to patent that method. In the sense, it is not patentable. Okay, so any innovations against law is not patentable, and innovations related to artistic works, books, is not kind of patentable, and innovation related to traditional practices is not patentable. Traditionally, they are doing some practices, and if you want to patent that, no, it is absolutely no. And the section 4 is not listed here. Section 4, like say, anything related to energy is not patentable. You are devising, you're identifying some perpetual engine or motion, perpetual devices where it is not utilizing any energy efficient devices. It is not patentable because it comes under section 3 and 4. So any innovation related to nuclear and atomic energy is not patentable. Okay, and so as we are we listed about IP process and global innovation index, and what is all about the patent forms, types of patents, and non-patentable inventions. These are all the connecting the dots. We have a lot of things like incubators are there, and then patent facilitating cell is there within our university, and departments, various streams are there, across the streams are there. And we are talking about commercialization of IP. In the sense, all these things should be connected each other. Okay, and even to the core, you have to connect with the neighboring institute, neighboring central institutes, and to some extent, yes, IITs we can connect and we can work parallelly. So, and at the same time, we have to state that we have to increase our core competence also, and we have to make sure that we are connecting the dots. So if you're working on a particular research concept, and if I say environmental bioremediation is my core competence, I have to know about everything, proper, what is the proper assays, which microorganism might be efficient to for bioremediation, and so on. So all these things should be taken care of when you sharpen your core competence. And then when you identify the problem statements, think about the stakeholders. If you're doing some research or innovation, think about the stakeholders for whom I'm doing it, for whom I'm making this particular product. Did I made a design thinking process and make an empathy and identify the problem and validate the particular problem statement? I have a lot of customer personas and their suggestions, whether I'm taken into my research and innovation or not. Like all these things you need to think about. When you do that, when you streamline all these things, everything, and automatically your success is institution success, and institution success is a kind of state success, and state success is a country's success. So automatically in global innovation index and an IP index, our ranking will increase a lot. So in that way we need to work. Okay, so I think I've completed my session. So if at all any anything you want to ask, then we can. I'm happy to connect.
Sir, am I audible?
Yes, ma'am.
Yeah, sir. Thank you very much, sir. That was very informative and resourceful. I'm extremely sorry for the inconvenience that I had in the beginning, but thank you so much for bearing us till the very end. On behalf of our students and our staff, I express my heartfelt thanks for the researches, the findings, the slide you had to provide with us, a complete package of knowledge to our young minds. Thank you very much, sir. Now, on behalf of our students, I have a question for you, sir.
Yeah.
Shall I proceed, sir?
Yes, please.
Yeah, what is the role of entrepreneur in contributing towards the intellectual property rights, sir?
Of course, yes. You asked a wonderful question. the role of entrepreneur is like, when you say like you want to become an entrepreneur, and you have something called idea in your mind, right? The idea might be not in a physical form. It is like, TRL, technology readiness level 0, we'll assume. You don't have
Yes.
any kind of equipment or a proof of concept to support you. Once you
Yes.
make a proof of concept, what is your next step? Like, there are some of the funding schemes which is available to convert your idea into proof of concept. For that, like, some of the
Yes.
funding, like we have a DST Newgen IDC, which support idea to POC. And for the next level of funding, like, you can't be able to become an entrepreneur with the seed funding, like 2 lakhs, which is provided by the government, DST. So in that case, we can have the next level of funding. All the state and central government schemes are there, from 10 lakhs to 2 crores. I'm talking about. There are fundings is available. To tap that particular fund, definitely you need to file a patent application. You need to have IP. You need an IP protection for your proof of concept. So for that,
Yes.
you need to file a patent for the proof of concept, and then you need to also follow up. Like, filing the patent and getting an application number alone won't be sufficient. Making follow up, whether you identify, like, you have to make a follow up for application, publication, then reply, and then getting the grant certificate. Doing that, you have to make a proper follow up. If you do that, I'm damn sure that the funding through the central government schemes, scale up funding, and also VC funding, venture capitalist fund, and then angel investors fund, that is also you can tap on. And this is a kind of protection that you have for your innovation. So that's how, every patent, you will be addressed as innovator, and an entrepreneur should be an innovator too. So that in that way, it will definitely adds value to an every entrepreneur.
Okay, sir. Thank you very much, sir. And another question, sir. Sorry to interrupt. Um,
Yeah.
we know that this is completely a technical field, and we have to work theoretically. But what role does the innovation and creativity play with this intellectual property? Can you explain it a bit?
Yes. For this, I think you have to distinguish between creativity and innovation too. Like, when it comes to creativity, everything is creative. Like, you make something creative, and you make something innovative. What is the difference between this? When your creativity converts into money, when your creativity is sellable, you sell your creativity, that is called innovation. When you have customers to buy your creativity, that is an innovation. You can blindly go for it. So
Yes, sir.
so you need to just think about, all the kind of creativity is not, you can't able to sell it. So when there should be some need in the market, and your creativity should address some of the problem statement that based on the countries I'm talking about. Like, India has a lot of problem statement that we need to work on, and you have to apply your creativity in that problem statement and convert the creativity into innovation. Then automatically everything will be pouring off.
Okay,
And
okay, sir. Thank you.
one of the 3 criteria, the first criteria I've said is novelty, utility, and inventive step. No, the novelty comes automatically when you say like your product is innovative. No, automatically it fits in. The novelty also, getting.
Okay, sir.
Yeah.
Thank you very much, sir. Thank you very much for your answers. Now, time to express our gratitude and word of thanks. I'm sure we had a lot to take away from this session. Thank you very much, sir. To begin with, I'd like to start by thanking our college management, our chancellor, vice chancellor, provost, vectors, and our joint registrar, Dr. Subhashri ma'am, our students, and a special thanks to our chief guest to stay patient and attend the session and give valuable insights from this. And we thank everyone who stayed till the very end. And thank you so much for bearing with us and have a nice day. Thank you very much, sir.
Thank you so much.